People of the State of Michigan versus Gloria Jean Dabbs, filed 25-7096FH. Counsel, you want to state your appearance, beginning with people?
Melissa Goodrich, Lynn County Prosecutor.
No, Nightingale, for Ms. Dabbs, who appears, I think in person. I can't see her, though. I think we're good to go, Judge.
Okay. All right. And this matter had been scheduled for a trial. It was removed off the trial docket based on an anticipated plea. And I think because of the jail cap on that and her credit, counsel wanted to move the hearing up to today for entry of a plea and sentencing. Is that how we're going to proceed today, Mr. Nightingale?
That is correct. Thank you, Judge.
All right. So, Ms. Dabbs, by this plea agreement, you'd be pleading guilty to an amended charge of operating while intoxicated, second offense, and that would be a misdemeanor punishable by 5 days to 1 year in jail and or a $200,000 to $100,000 fine. Do you understand that maximum penalty?
Yes.
Did you read and understand the rights listed on the advice of rights form?
Yes.
You understand that that form lists the rights that you give up by entering a plea instead of going to trial?
Yes.
The plea agreement provides in exchange for your plea to the misdemeanor charge, the felony would be dismissed, and there's a sentence agreement that you serve 6 months of incarceration, that'd be a straight jail sentence and credit for the time that you have been serving. Do you understand the terms of that plea agreement?
Yes.
All right. Knowing all this, Ms. Dabbs, how do you wish to plead the charge of operating while intoxicated, second offense?
Yes.
So back on July 8th of 2025, were you operating a vehicle in Sheboygan County?
No.
Where were you operating that vehicle?
Judge, if the complaint date is actually incorrect. I believe the date was 7/3.
7/3. Okay.
So I think that's why she says no.
Okay, very good. On July 3rd, were you up in Ms. Goodrich? Is that fine?
That is fine.
Okay. On July 3rd of last year, were you operating a motor vehicle in Sheboygan County?
Yes.
Okay. And were you operating that vehicle on a public highway, that being North Straits Highway?
Yes.
Before you operated that vehicle, had you consumed alcoholic beverages?
Yes.
Did you have some contact with police officers?
Yes.
Did they end up giving you a test to determine the amount of alcohol in your body?
Yes.
Do you remember the results of that test?
No.
Were they above the legal limit of 0.08?
Yes.
Okay. And you don't challenge that test result?
No.
And at that time, did you have a previous conviction for operating while intoxicated? Looks like most recently back in 2007 in Knox County, Tennessee.
I think the actual arrest was 2003, but conviction in 2007.
Okay.
But yes.
Okay. And Mr. Nightingale, that of course would be outside the 7-year window for an OWI second, but she's charged with a greater offense of the third within any period of time. So do you consent to the entry of the lesser offense?
I do. Thank you.
All right. Are you satisfied with that factual basis, Mr. Nightingale?
I am, Aaron. Thank you.
Ms. Goodrich?
Yes.
All right. Ms. Dabbs, I find that your misdemeanor plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea, and we can proceed to immediate sentencing then. By my calculation, Mr. Nightingale, I think I've got her at 152 days credit as of today, according to the jail log. Anything you want to say on her behalf?
Yes, Your Honor, please. So asking the court to accept the agreement of the parties here. Ms. Dabbs comes before the court, I believe 70 years of age. She has extremely limited criminal history. Her last conviction was about 20 years ago, and I think as she's informed the court that her recollection is that it's actually a prior case that was dismissed and then refiled. And so it looks like it's later in time, but when in fact it was earlier in time. Nonetheless, 20 years, I think, since she's had any history like this, has no prior felonies. This was an incident from July 3rd of last year. There was no crash here. The 911 call does report some erratic driving behavior, but none was actually observed by the officer who pulls her over. Ms. Dabbs was fairly compliant, acted appropriately with the officers. Her blood alcohol content was a 0.113, so not a super drunk, but above the 0.08, as the court's already asked her about. So nothing particularly concerning about the facts of the case itself. I'm sure that the court, is obviously and always concerned with prior OWIs. We hope that since she's had 20 years since that last DUI, since this 6 months of jail is the top of the guidelines for her on an OWI third, that the court will accept this agreement, will consider it appropriate and reasonable under her specific circumstances, not place her on probation. She is on a fixed income. As to her person, Ms. Dabbs obviously received that letter from the pastor at the jail. She's obviously at least attempting to take her time in there seriously and rehabilitate not just herself, but some of the other people, the other folks that are in there. She is a lifelong educator, and I think that's not ever something that's going to leave her, and something that she's taken to the jail with her, trying to pass on her experience, to the younger folks that are in there. This case itself, I think Ms. Dabbs was certainly dealing with an amount of grief that she has not probably, really acknowledged or fully dealt with at this point. Her husband passed a few years ago at this point, I believe, but it was like a long and drawn out passing. I think that he had some sort of cancer, and through that treatment process, she was essentially bankrupted. Almost lost everything. Thankfully she's been able to keep her home, and that I think has been a big wake-up call for her. This period of incarceration almost cost her her home, and everything inside of it. And I don't think that this court's going to see Miss Dabbs again, at least in this capacity. She is a good and fairly law-abiding member of the community, and I hope that this is the last time that she has this type of run-in with the law. We are very grateful for the plea agreement that Ms. Goodrich and I came to. I think that it fairly and appropriately deals with what happened here, and ask the court to accept the same. Thank you.
Ms. Dabbs, you don't have to tell me anything today, but you're welcome to. Is there anything you want to tell me or no?
I can't think of anything.
That's fine. Any recommendations from the people, Ms. Goodrich?
Yes, Sean, I'd be asking the court to follow the plea agreement. The beginning of this case was rough. Ms. Dabbs kept violating her bond, but yet didn't want to go to rehab or admit that she had an issue. I was really happy to see this letter from Pastor Jones that she's turned the corner and has invested in achieving sobriety, and also had the empathy to help others along the way. So I would ask the court to follow the plea agreement. Thank you.
Okay, thank you. Well, Ms. Dabbs, if you please stand for the court sentence. Well, Ms. Dabbs, you've got some prior convictions. They were a long time ago, which is why you've got this outcome here today, which I am going to follow. I share the prosecutor's concern about, that you seemed to be either unable or unwilling to stop drinking while you were on bond for this case. That does give me some worry about future, and with the history that you have now with a recent drunk driving. If you come back in front of me for a drunk driving, it will almost certainly be sending you to the state prison, which at your stage in life, I guarantee you do not want that to happen.
No,
So,
I do not, but may I say something?
sure.
I did not drink on bond.
Why did we revoke your bond?
They were dilutes.
Oh, okay. Well, then you were, yeah, okay.
But
That worries me even more.
there was, according to several people I've talked to, it's from the caffeine that I was drinking. And unfortunately, eating pineapple, which I didn't know would eat the protein, was supposed to keep it from.
So, Ms. Dabbs, I don't want to cut you off, but the judge is about to accept the agreement of the parties, and so I would not
Don't
make.
worry, I'm not gonna. Yeah, I'm not. He's worried because you're like giving me excuses, and that's usually not a good recipe for me to follow the agreement. But I'm not going to hold that against her. I'm going to follow the agreement, Mr. McGee.
Thank you, Judge.
But Ms. Dabbs, I guess I just want to tell you, I'm going to follow this agreement, but I'm concerned that we're not done with you. And I guess I just want to promise you want to be done drinking and driving. I hope you're done drinking, but if you want to get as drunk as you want in your own home, that's not going to be illegal for you. It's going to be bad for you given your history, but that's up to you. But if you get behind the wheel after you've been drinking, I promise you and I are going to have a very different interaction.
It won't happen again, Your Honor.
Okay, I sure hope you're right about that. I'm not in charge of that, you are. So understand, if in a year or two I'm sending you to prison for another drunk driving, that's not my fault. That's going to be your fault and your decision. All right, well, given the number of prior drunk drivings, I'm a bit reluctant about this, but the fact that they are so long ago and there's been such a length of time without problem, I'm going to follow the agreement this time and sentence you to 6 months in the Sheboygan County Jail with credit for 152 days credit State cost of $50, crime victims assessment of $75, $350 in court costs, and a $200 penal fine for a total of $675. We'll get the judgment and sentence done today, and I imagine with credit you should be released. The jail will calculate your out date, and then you're all set with us other than paying that fine off. You won't be on probation. Okay. Good luck to you. All right. Thank you very much, Mr. McNeil.
Thanks, Judge. Have a good day, and thanks for squeezing us in.
You too. All right. That'll conclude our docket this morning.